SwayamPrabha. Digital India. Educated India.
Hello students, welcome to SwayamPrabha. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. I and my colleague Dr. Saurabh Rana are delivering this course on Procedural Law on Crimes, Bharatiya Nagarik Suraksha Sanhita 2023. Today is the 16th lesson of that series. This lesson is titled Judgment and Sentencing. To begin with, I would like to quote the judgment delivered by Supreme Court in State of Madhya Pradesh versus Santosh Kumar. The court observed, "The law regulates social interests, arbitrates conflicting claims and demands. Security of persons and property of the people is an essential function of the state. It is sought to be achieved through instrumentality of criminal law. Undoubtedly, there is a cross-cultural conflict where living law must find answer to the new challenges, and the courts are required to mold the sentencing system to meet the challenges. The contagion of lawlessness would undermine social order and lay it in ruins. Protection of society and stamping out criminal proclivity must be the object of law, which must be achieved by imposing appropriate sentence. Therefore, law as a cornerstone of the edifice of order should meet the challenges confronting the society." Friedman, in his Law in Changing Society, stated that state of criminal law continues to be, as it should be, a decisive reflection of social consciousness of society. Therefore, in operating the sentencing system, law should adopt the corrective machinery or the deterrence based on factual metrics. By depth modulation, sentencing process be stern where it should be and tempered with mercy where it warrants to be. The facts and given circumstances in each case, the nature of the crime, the manner in which it was planned and committed, the motive for commission of the crime, the conduct of the accused, the nature of weapons used, and all other attending circumstances are relevant facts which would enter into the area of consideration. For instance, a murder committed due to deep-seated mutual and personal rivalry may not call for penalty of death, but an organized crime or mass murders of innocent people would call for imposition of death sentence as deterrence. Section 258 of the Bharatiya Nagarik Suraksha Sanhita, the old section 235 of CRPC, it lays down provisions regarding judgment of acquittal or conviction. So, after hearing arguments and points of law, if any, the judge shall give a judgment in the case. And then students, as you can see, the portion that is highlighted as in red is the new provision which has been introduced by the BNSS in 2023. So, this part was not there in the earlier CRPC. So, what the law says? After hearing arguments and points of law, if any, the judge shall give a judgment in the case as soon as possible. And further it qualifies this with within a period of 30 days from the date of completion of arguments, which may for specific reasons extend to a period of 60 days. So, you see judgments, they can not be reserved for very long time. Now, there is a specified timeline attached to the law, that is, it says as soon as possible, but within a period of 30 days. So, it could be the very next day, it could be within a week, but it should be delivered as early as possible. But then in some cases, if there are specific reasons, it may extend to 60 days, but not beyond 60 days. The accused, if he is convicted, then the judge shall, unless he proceeds in accordance with provisions of section 401, that is where he orders to release on probation of good conduct of or after admonition, the judge shall hear the accused on the questions of sentence and then pass sentence on him according to law. So, students, section 235 clause 2 is a very, very important provision in law. Why? Because this talks about hearing the accused on the questions of sentence and then pass sentence according to the law. What is the sentence prescribed by law? That is already given in the Bharatiya Nyaya Sanhita 2023, which is the substantive law. See, for every transgression of law, a punishment has been prescribed. But then sometimes we prescribe the maximum punishment and there is a discretion with the courts to award a lesser sentence. Sometimes what the law does is, it prescribes a minimum punishment and then there is a discretion with the courts to award a higher punishment. So, how does the judiciary exercise this discretion? They have to exercise this discretion in accordance with certain well settled principles. And while exercising their discretion, we have a sentencing mechanism wherein the accused and the prosecution both have an opportunity to present their views as to why the accused can plead why he needs to be awarded a lesser sentence, whereas the prosecution can plead why the accused needs to be awarded a higher sentence. See, at the stage of sentencing, we are not going into the question of guilt or innocence of the accused person, because that has already been established. So, now what we are arguing about is, although the conviction has been established, but are there any aggravating factors or are there any mitigating factors which can be taken into consideration by the courts, and thereafter the court can exercise its discretion to decide whether a higher sentence has to be awarded or whether a lesser sentence has to be awarded in that case. The necessity of inserting subsection 2 in section 235, that is the old CRPC, was highlighted by the Law Commission in its 41st report, which reads as follows. It is now being increasingly recognized that a rational and consistent sentencing policy requires the removal of several deficiencies in the present system. One such deficiency is the lack of comprehensive information as to the characteristics and background of the offender. The aims of sentencing become all the more so in the absence of information on which the correctional process is to operate. The public as well as the courts themselves are in the dark about the judicial approach in this regard. We are of the view that the taking of evidence as to the circumstances relevant to sentencing should be encouraged, and both the prosecution and the accused should be allowed to cooperate in the process. The Law Commission in its report had opined that the taking of evidence as to the circumstances relevant to sentencing should be encouraged in the process. The Parliament, it is seen, has accepted the recommendation of the Law Commission fully, and therefore, it has enacted subsection 2 to section 235. This is the old law. So, subsection 2 of section 235 clearly states that the hearing has to be given to the accused on the question of sentence, but the question is, what is the object and purpose of hearing, and what are the matters to be elicited from the accused? Of course, Full opportunity has to be given to produce adequate materials before the court, and if found necessary, court may also give an opportunity to lead evidence. Now, evidence on what? Evidence which has some relevance on the question of sentence and not on the question of conviction, because see, conviction has already been established. So, now what we are arguing before the court is only a question of sentencing, not of the guilt of the innocence of not of the guilt or the innocence of the accused person. But the further question to be examined is whether, in the absence of adding any materials by the accused, has the court any duty to elicit any information from whatever sources before awarding sentence, especially capital punishment? Psychological trauma which a convict undergoes on hearing that he would be awarded capital sentence, that is death, has to be borne in mind by the court. Convict could be a completely shattered person, may not be in his normal senses, may be dumbfounded, unable to speak anything. Can, in such a situation, the court presume that he has nothing to speak or mechanically record what he states without making any conscious effort to elicit relevant information which has some bearing in awarding a proper and adequate sentence? Awarding death sentence is always an exception, that is to be awarded only in the rarest of rare cases. The object of hearing under section 235 clause 2 of the CRPC being intrinsically and inherently connected with the sentencing procedure, the provisions of section 354(3) CRPC, which calls for recording of special reason for awarding death sentence, must be read conjointly. The court held that such special reasons can only be validly recorded if an effective opportunity of hearing as contemplated under section 235(2) CRPC is genuinely extended and is allowed to be exercised by the accused who stands convicted and is awaiting the sentence. Then there was a leading judgment in the case of State of Madhya Pradesh versus Santosh Kumar. This is a 2006 judgment delivered by the Supreme Court of India, in which what the court said? This is a judgment regarding the principle of proportionality. That is, we have to bear in mind what is the gravity of the crime and what is the quantum of sentence that an accused is sentenced to. So, the criminal law adheres in general to the principle of proportionality in prescribing liability according to the culpability of each kind of criminal conduct. It ordinarily allows some significant discretion to the judge in arriving at a sentence in each case, presumably to permit sentences that reflect more subtle considerations of culpability that are raised by the special facts of each case. Judges, in essence, affirm that punishment ought always to fit the crime, yet in practice sentences are determined largely by other considerations. Sometimes it is the correctional needs of the perpetrator that are offered to justify a sentence. Sometimes the desirability of keeping him out of circulation, and sometimes even the tragic results of his crime. Inevitably, these considerations cause a departure from just desert. Now, what is just desert? We will be talking about that as the basis of punishment and create cases of apparent injustice that are serious and widespread. Proportion between crime and punishment is a goal respected in principle, and in spite of errant notions, it remains a strong influence in the determination of sentences. The practice of punishing all serious crimes with equal severity is not unknown in civilized societies, but such a radical departure from the principle of proportionality has disappeared from the law only in recent times. Even now, for a single grave infraction drastic sentences are imposed. Anything less than a penalty of greatest severity for any serious crime is thought then to be a measure of toleration that is unwarranted and unwise. But in fact, quite apart from those considerations that make punishment unjustifiable when it is out of proportion to the crime, uniformly disproportionate punishment has some very undesirable and practical consequences. So, we need to mold sentencing to meet challenges of our justice system, and this was emphasized by the court in Jashubha Bharat Singh Gohil versus State of Gujarat. It was held that in the matter of death sentence, the courts are required to answer new challenges and mold the sentencing system to meet these challenges. The object should be to protect the society and to deter the criminal. It is expected that the courts would operate the sentencing system so as to impose such sentence which reflects the conscience of the society, and the sentencing process has to be stern where it should be. Even though the principles were indicated in the background of death sentence and life sentence, the logic applies to all cases where appropriate sentence is the issue. So, imposition of sentence without considering its effect on the social order in many cases may be in reality a futile exercise. The social impact of the crime, that is, where it relates to offences against women, dacoity, kidnapping, misappropriation of public money, treason and other offences involving moral turpitude or moral delinquency, which have great impact on social order and public interest, cannot be lost sight of and per se require exemplary treatment. Any liberal attitude by imposing meagre sentences or taking too sympathetic view merely on account of lapse of time in respect of such offences will be counterproductive in the long run and against societal interest, which needs to be cared for and strengthened by string of deterrents inbuilt in the sentencing system. In another case, Mahesh versus State of MP, the Supreme Court, while refusing to reduce the death sentence, observed thus: it will be a mockery of justice to permit the accused to escape the extreme penalty of law when faced with such evidence and such cruel acts. To give the lesser punishment for the accused would be to render the justicing system of the country suspect. The common man will lose faith in courts. In such cases, he understands and appreciates the language of deterrence more than the reformative jargon. Society's reasonable expectation is that the deterrent punishment commensurate with the gravity of offence be awarded. When the crime is brutal, shocking, the collective conscience of the community, sympathy in any form would be misplaced and it would shake the confidence of public in the administration of criminal justice system. So, as held by the Supreme Court in Om Prakash versus State of Haryana, the court must respond to the cry of the society and to settle what would be a deterrent punishment for what was an apparently abominable crime. Undue sympathy to impose inadequate sentence would do more harm to the justice system to undermine the public confidence in the efficacy of law and society could not long endure under such serious threats. It is therefore the duty of every court to award proper sentence having regard to the nature of the offence and the manner in which it was executed or committed. See what the courts have said, that sentencing should be done in a manner that the accused gets the message. See, we cannot adopt the reformative approach in every case. Sometimes it is a very grave, a heinous crime. The accused is a repeat offender, who has been convicted of such a crime. In such cases, if we are showing mercy to that person, so what are we doing? We are eroding the public confidence in the efficacy of the law. And when these kind of judgments come, the society would also lose its balance. So what has to be done? We need to strike a proper balance between leniency to be exercised in case of first time offenders or those who are convicted of petty crimes, and gravity of crime to be kept into consideration, and accordingly appropriate punishment to be awarded to the accused person who is not deserving of any mercy or any lenient treatment given the facts and circumstances of the particular case. Then this case of Dhananjay Chatterjee versus State of West Bengal, the Supreme Court has observed that shockingly large number of criminals go unpunished, thereby increasingly encouraging the criminals and in the ultimate making justice suffer by weakening the system's creditability. The imposition of appropriate punishment is the manner in which court responds to the society's cry for justice against the criminal. Justice demands that courts should impose punishment befitting the crime so that courts reflect public abhorrence of the crime. The court must not only keep in view the rights of the criminal, but also the rights of the victim of the crime and the society at large while considering the imposition of appropriate punishment. In Ravji versus State of Rajasthan, the Supreme Court held that it is the nature and gravity of the crime, but not the criminal, which are germane for consideration of appropriate punishment in a criminal trial. The court will be failing in its duty if appropriate punishment is not awarded for a crime which has been committed not only against the individual victim, but also against the society to which the criminal and victim belong. The punishment to be awarded for a crime must not be irrelevant, but it should conform to and be consistent with the atrocity and brutality with which the crime has been perpetrated, the enormity of the crime warranting public abhorrence, and it should respond to the society's cry for justice against the criminal. If for extremely heinous crime of murder perpetrated in a very brutal manner without any provocation, most deterrent punishment is not given, the case of deterrent punishment will lose its relevance altogether. So, while analyzing the evolution of sentencing policy in India and stressing on the need for further evolution, the Supreme Court emphasized on making the sentencing process a principled one rather than judge-centric one, and held that a relook is needed at some conclusions that have been taken for granted, and we need to continue the development of the law on the basis of experience gained over the years and views expressed in various decisions of the court. This was the Supreme Court judgment in Sangeet and another versus State of Haryana 2013 judgment. And then this is a common sentiment which has been echoed by the Supreme Court in a number of cases like Holi Ram Bordoloi versus State of Assam, Ankush Maruti Shinde versus State of Maharashtra, Mohfil Khan and another versus State of Jharkhand. In all these decisions, there was a common sentiment of the courts, and what was that? In dealing with sentences, the courts have applied the crime test, criminal test and the rarest of the rare test. These tests examine whether the society abhors such crime and whether such crimes shock the conscience of the society and attract intense and extreme indignation of the community. Courts have further held that where the victims are helpless women, children or old persons and the accused displayed depraved mentality, committing crime in a diabolic manner, the accused should be shown no remorse and death penalty should be awarded. So, leniency cannot be the norm. There have to be conditions such as warrant a lenient treatment of an accused person. but for those who are hardened criminals, who refuse to learn from their mistakes and who refuse to give up on the way of crime, it is only the extreme penalty that would suffice. Now, let us talk about what is the concept of just deserts. See, this is what is the concept of karma as people believe in, and they believe that while we do not have to wait for the nature to serve what an accused deserves, it is for the lawyers, it is for the prosecutors, it is for the criminal justice system to ensure that the accused is punished in a way that is proportionate to the crime that he has committed. So, what is just deserts? This refers to the philosophy of a fair and appropriate punishment that is related to the severity of a crime that has been committed. The principle of just desert requires that punishment should be proportionately determined in the light of the unfair advantage that the offender has obtained by violating the law. So, this means an action that deserves appropriate recompense. Punishment should be ideally proportionate to the gravity of the crime. So, thus desert refers to what is deserved, whether a reward or punishment. So, as per this philosophy, punishment is justified. Why? Because a criminal deserves it. The criminal has done an act which makes him liable for such punishment. There is this judgment, Santa Singh versus State of Punjab. The Supreme Court has extensively dealt with the nature and scope of the old section 235 clause 2 CRPC, stating that such a provision was introduced in consonance with the modern trends in penology and sentencing procedures. The court noticed today more than ever before, sentencing has become a delicate task requiring an interdisciplinary approach and calling for skills and talents very much different from those ordinarily expected of lawyers. In this case, the requirements of section 235(2) were not complied with, inasmuch as no opportunity was given to the appellant after recording his conviction to produce material and make submissions in regard to the sentence to be imposed on him. The court noticed that the Sessions Court chose to inflict death sentence on the accused, and the possibility could not be ruled out that if the accused had been given an opportunity to produce material and make submissions on the question of sentence as contemplated by section 235 subsection 2, he might have been in a position to persuade the Sessions Court to impose a lesser penalty of life imprisonment. Therefore, the court held the breach of mandatory requirement of section 235 subsection 2 could not in the circumstances be ignored as inconsequential, and it can vitiate the sentence of death imposed by the Sessions Court. The court therefore allowed the appeal and set aside the sentence of death and remanded the case to the Sessions Court with the direction to pass appropriate sentence after giving an opportunity to the accused to be heard. Further, in Santa Singh, the court also held as follows: the hearing contemplated by section 235 subsection 2 is not confined merely to hearing oral submissions, but it is also intended to give an opportunity to the prosecution and the accused to place before the court facts and material relating to various factors bearing on the question of sentence, and if they are contested by either side, then to produce evidence for the purpose of establishing the same. The obligation to hear the accused on question of sentence, which is imposed by section 235 subsection 2 of CRPC, is not discharged by putting a formal question to the accused as to what he has to say on the question of sentence. The judge must make a genuine effort to elicit from the accused all information which will eventually bear on the question of sentence. This was held by the Supreme Court in the case of Muniappan versus State of Tamil Nadu. Thereafter, in 1991, in the case of Malkait Singh versus State of Punjab, the Supreme Court indicated the necessity of adjourning the case to a future date after convicting the accused and held as follows. On finding that the accused has committed the charged offences, Section 235 subsection 2 of the Code empowers the judge that he shall pass sentence on him according to law on hearing him. Hearing contemplated is not confined merely to oral hearing, but also intended to afford an opportunity to the prosecution as well as the accused to place before the court facts and material relating to various factors on the question of sentence, and if interested by either side, to have evidence adduced to show mitigating circumstances to impose a lesser sentence or aggravating grounds to impose death penalty. Therefore, sufficient time must be given to the accused or the prosecution on the question of sentence to show grounds on which the prosecution may plead or the accused may show that the maximum sentence of death may be the appropriate sentence or the minimum sentence of life imprisonment may be awarded, now as the case may be. Now, what is the effect of non-compliance with the provisions of section 235 subsection 2 of the CRPC? So, there was this judgment in Alauddin Mia and others versus State of Bihar, in which the Supreme Court held that this is a provision that is mandatory in nature. Now, this is not a discretion with the courts. Now, this is the mandate of the legislature, and the courts, they are bound to follow it. See, the operative portion of the judgment reads as follows. The requirement of hearing the accused is intended to satisfy the rule of natural justice. It is a fundamental requirement of fair play that the accused, who was hitherto concentrating on the prosecution evidence on the question of guilt, should, on being found guilty, be asked if he has anything to say or any evidence to tender on the question of sentence. This is all the more necessary since the courts are generally required to make the choice from a wide range of discretion in the matter of sentencing. To assist the court in determining the correct sentence to be imposed, the legislature introduced subsection 2 to section 235. The said provision therefore satisfies a dual purpose. It satisfies the rule of natural justice by according to the accused an opportunity of being heard on the question of sentence, and at the same time it helps the court to choose the sentence to be awarded. Since the provision is intended to give the accused an opportunity to place before the court all the relevant material having a bearing on the question of sentence, there can be no doubt that the provision is salutary and must be strictly followed. It is clearly mandatory and should not be treated as a mere formality. Section 392. It explains what is judgment. Now, this was earlier 353 under the Code of Criminal Procedure. So, what does the law say? The judgment in every trial in any criminal court of original jurisdiction should be pronounced in open court. So, whether it is any criminal trial, you see, every trial in any criminal court of original jurisdiction, that is after the trial, the judgment has to be pronounced in open court by the presiding officer immediately after the termination of the trial or at subsequent time not later than 45 days, of which notice shall be given to the parties or their advocates. And by delivering, how is the judgment to be delivered? By delivering the whole of the judgment, by reading out the whole of the judgment, or by reading out the operative part of the judgment and explaining the substance of judgment in a language which is understood by the accused or his advocate. See students, what happens, judgments we have seen sometimes they run into hundreds of pages, and why does that happen? Because judgments, they have to be self-explanatory, In this sense, judgments, they have to contain all information as to what were the accusations or allegations, how they were countered by the defense, what was the evidence that was tendered, who were the witnesses that were examined, what was stated by them, how it was countered by the other party. Then on the basis of that, the court arrives at certain observations, findings, on the basis of which it draws conclusions, on the basis of which finally the judgment is pronounced. That is what has to be now done. What is the sentence that has been prescribed, or what is the judgment in this case? So while explaining all this, sometimes we need a lot of it runs into several pages, and a lot of time would be involved in case the judge was to necessarily read it all in the open court. So what can the judges do? They can read out